FAYE's General Code prescribes how and what FSPs and other role players must do in order to comply with the FAYES Act. Chapter 8 introduces you to some of these requirements. You will learn how the FSP must account for money and funds received from clients and how to ensure adequate disclosure to clients. The chapter also looks at ethical conduct on the financial services industry and equips you to ensure that the required steps are taken when giving advice to clients. We also discuss transparency, conflict of interest, risk management, contingency planning, insurance, and advertising requirements. The General Code of the FAYES Act applies to the provision of financial services and includes the procedures to be followed when an FSP receives financial products, funds or premiums from clients and holds it in custody before paying it over into a bank account. These provisions are subject to any other legislation which may be more prescriptive with regards to the custody of financial products and funds. The FSP must have a separate bank account at a bank designated to receive funds and premiums from clients, which is separate from any other funds. The FSP is responsible for bank charges, except the charges that relate to deposit or withdrawal, which the client must pay. The FSP must pay all interest accumulating in the account to the client or owner of the funds. The provision in Section 10(1) of the General Code does not apply to a provider who meets the requirements of Section 45 of the Short-Term Insurance Act. When the FSP receives funds from a client without a bank being involved, it must issue a written confirmation when the money is received. The money must be paid into the bank account within 1 day of receipt. When title documents are lodged with an FSP on behalf of a client, the FSP must issue a written confirmation when the documents are received, indicating description of the documents so that they can be identified. If the FSP or a designated third party receives funds or financial documents, reasonable steps must be taken to ensure that they are adequately safeguarded and that the funds or financial products are dealt with according to the client's mandate, that the funds or financial products are easily distinguished from the FSP's funds or assets, that the client has easy access to any amount paid into the separate account, less all relevant deductions, but subject to all other applicable laws. The General Code, the specific codes for administrative and discretionary FSPs, as well as the Code of Conduct for FSPs and their representatives involved in forex investment business, have specific requirements regarding disclosures which must be made to clients. Disclosure is one of the key protection objectives of the Act. Clients must be able to make informed decisions and choices and must therefore receive all the relevant information. Disclosure must be made on product information, any commission, personal interest, or benefit the representative may get as a result of the client entering into a transaction or buying a product. Disclosure of product supply information. The FSP must give clients information on product suppliers as soon as possible, where appropriate. Oral information must be confirmed in writing within 30 days. Disclosure must include the following: name, physical location, postal and telephone contact details of the product supplier, the contractual relationship between FSP and the product supplier, and whether the FSP has contractual relationships with other product suppliers, names and contact details of the relevant compliance and complaints department of the product supplier, if applicable, that the FSP holds more than 10% shares or has the equivalent financial interest in the product supplier, and that the FSP received more than 30% of total remuneration, including commission, in the last 12 months from the product supplier. A product supplier who is also an FSP and who has an intermediary or similar contract with another provider must ensure that when asked by the other provider, it provides all the required information about itself and the product so that the other provider can comply with the disclosure requirements. Disclosure of FSP information. The FSP must give clients information on product suppliers as soon as possible, where appropriate. Oral information must be confirmed in writing within 30 days, if a transaction was concluded. Disclosure must include the following: full business and trade names, registration number, postal and physical addresses, telephone, cellular phone number, and internet and email addresses in respect of the relevant business carried on. as well as the names and contact details of appropriate contact persons or officers. Information about the legal relationships between FSP, product supplier, and representative, so that it is clear to the client who accepts responsibilities for the action of the FSP or rep, or the extent to which the client must accept such responsibility. Names and contact details of the relevant compliance departments, or in the case of the representative, such detail concerning the provider to which the representative is contracted. Information of the financial services which the provider is authorized to provide, and of any conditions or restrictions applicable to the license, and whether the FSP has guarantees or professional indemnity or fidelity insurance cover or not. Whether a representative of a provider is rendering services under supervision, the existence of a specific exemption applicable to the FSP. Specific disclosure requirements of the Code of Conduct for authorized FSPs and their representatives involved in forex investment business. The name and address of the foreign forex service provider or clearing firm used, if applicable. The name and address of the foreign regulator regulating the foreign forex service provider or clearing firm, and whether such provider or firm is approved or registered by such regulator. The name and address of the foreign regulator under whose jurisdiction the dealing activity falls. Whether the foreign forex service provider or clearing firm which holds investments on behalf of the client has insurance cover to cover the risk of losses due to fraud, dishonesty and negligence by the foreign forex service provider or clearing firm, and the extent of such cover. Disclosure on commissions. General commission disclosures. Clients must be advised of the commission payable in respect of a financial product or service in rand value amounts where possible. Disclosures must include the following: the nature, extent and frequency of any incentive, remuneration, consideration, commission, fee or brokerages which will or may become payable to the provider, directly or indirectly, by any product supplier or any person other than the client. Fees or commissions for which the provider may become eligible as a result of rendering the service. The identity of the product supplier or other person providing or offering the valuable consideration. If the maximum amount or rate of the valuable consideration is prescribed by law, the provider may disclose the actual amount in monetary terms, or the basis for the calculation must be described if the amount is not determinable. Where a financial product is being replaced, the terminated product, by another financial product, the replacement product, full details must be disclosed of any incentive, remuneration, consideration, commission, fee or brokerages received directly or indirectly by the provider on the terminated product, and the same by the provider on the replacement product, where the provider rendered financial services on both the terminated and replacement product. Here is a list of the required disclosures on the products. Disclosure must include a written statement to the client at least once a year, which identifies the products and states the ongoing monetary obligations of the client, main benefits of the product, value of an investment, and how much is accessible to the client, and ongoing incentives, consideration, commission, fee or brokerage payable to the provider in respect of the product. Where a financial product is being replaced, the terminated product, by another financial product, the replacement product, held by the client, disclosure must be made of the actual and potential financial implications, costs and consequences of the replacement, including comparison of fees and charges between the two products, special terms and conditions, exclusions of liability, waiting periods, loadings, penalties, excesses, restrictions or circumstances in which benefits will not be provided, applicable to the replacement product compared to the terminated product. To what extent the replacement product is readily realizable or the relevant funds accessible compared to the terminated product. Loss of rights and minimum guaranteed benefits which will be lost due to the replacement. Transparency is a direct result of adequate disclosures. Disclosure will ensure transparency in the relationships between clients and FSPs, as well as between FSPs, product suppliers, and representatives. Transparency starts even before a financial service has been rendered. The information about products, financial services, FSPs, and product suppliers must be transparent in all its formats. Commission and related disclosures add to the transparency of the services and products, and it forms the cornerstone for avoiding or disclosing possible conflict of interest. The requirements for commission disclosures especially apply to the management of conflict of interest. Conflict of interest means a situation where a provider or representative has an actual or potential interest that may influence the objective exercising of obligations to the client, or prevent the rendering of financial services in an unbiased and fair manner. The General Code requires the following in respect of conflict of interest management. When a provider renders a financial service, the provider must disclose to the client the existence of any personal interest in the relevant service, or of any circumstance which gives rise to an actual or potential conflict of interest in relation to the service, and the provider must take all reasonable steps to ensure fair treatment of the client. Non-cash incentives offered and or other indirect consideration payable by another provider or product supplier or any other person to the provider could be viewed as a potential conflict of interest. The General Code was amended in 2010 to include more stringent measures relating to managing conflict of interest. These requirements include the following. A provider may not offer any financial interest to a representative of that provider for giving preference to the quantity of business secured for the provider to the exclusion of the quality of the service rendered to clients, or giving preference to a specific product supplier where a representative may recommend more than one product supplier to a client, or giving preference to a specific product of a product supplier where a representative may recommend more than one product of that product supplier to a client. Every provider other than a representative must adopt, maintain and implement a conflict of interest management policy that complies with the provisions of the Act. A conflict of interest management policy must be adopted by the sole proprietor of a provider, the board of directors of a provider, or in the case where a provider is not a company, the governing body of the provider. A provider must ensure that its employees, representatives, and where appropriate, associates are aware of the contents of the conflict of interest management policy and provide for appropriate training and educational material in this regard. A provider must continuously monitor compliance with its conflict of interest management policy and annually conduct a review of the policy. A provider must publish its conflict of interest management policy in appropriate media and must ensure that it is easily accessible for public inspection at all reasonable times. A provider or representative may not avoid, limit, circumvent, or attempt to avoid, limit, or circumvent compliance with this section through an associate or an arrangement involving an associate. Ethical conduct in the financial service industry includes the following. Disclosure and transparency by FSPs when applying for licenses and conducting business thereafter. Disclosure, honesty and integrity of representatives, key individuals and FSPs. Internal measures in an FSP such as a conflict of interest policy, code of ethics. Interaction between product suppliers and FSPs should be transparent and based on mutual understanding and applications of ethical conduct. Clearly defined rules such as the phase codes, which provide guidance and instructions towards ethical business conduct. Transparency and disclosure between clients and their financial advisors. Record keeping as required by the FASE Act also contributes towards ethical conduct. The General Code prescribes the steps to be followed and the action to be taken when representatives give advice to clients. The two main requirements of giving advice is establishing suitability and keeping a record of advice. Let's look at suitability first. A provider other than a direct marketer must, before providing a client with advice, do the following. Take reasonable steps to get information from the client on his financial situation, experience and objectives, and do an analysis for the purpose of the advice based on the information obtained. Identify the financial product or products that will be appropriate to the client's risk profile and financial needs, subject to the limitations imposed on the provider under the Act or any contractual arrangement. If there is a replacement of a financial product, full disclosures of that fact must be given. Where a financial product is being replaced by another financial product held by the client, disclosure must be made of the actual and potential financial implications, costs and consequences of the replacement, including comparison of fees and charges between the two products, special terms and conditions, exclusions of liability, waiting periods, loadings, penalties, excesses, restrictions, or circumstances in which benefits will not be provided, applicable to the replacement product compared to the terminated product, to what extent the replacement product is readily realizable or the relevant funds accessible compared to the terminated product, loss of rights and minimum guaranteed benefits due to the replacement. If a client did not provide the information required or the provider did not do an analysis because there was not enough time, the provider must inform the client that it is not done and must make sure that the client understands a full analysis in respect of the client was not done, that there may be limitations on the appropriateness of the advice provided, that the client should take particular care to consider on its own whether the advice is appropriate, considering the client's objectives, financial situation, and particular needs. If a client elects to conclude a transaction that differs from that recommended by the provider, or elects not to follow the advice furnished, or elects to receive more limited information or advice than the provider is able to provide, the provider must alert the client as soon as reasonably possible of the clear existence of any risk to the client, and must advise the client to take care to consider if any product selected is appropriate to the client's needs. Recording the advice. A provider must, subject to and in addition to the duties to keep records, maintain a record of the advice furnished to a client, including the following: a brief summary of the information and material on which the advice was based, the financial products that were considered, the financial product or products recommended with an explanation of why the product or products selected is or are likely to satisfy the client's needs and objectives. Where the financial product or products recommended is a replacement product, a comparison of all the details needs to be provided. The record of advice needs only be maintained if, as far as the provider knows, a transaction or contract is concluded by the client as a result of the advice given. A provider, except a direct marketer, must give the client a copy of the record of advice in writing. A Forex investment advisor must maintain a record of advice which includes the following: here are listed the general obligations of an FSP in handling complaints, as well as the specific obligations of the FSP. The risk management principles are generally the same across the financial services industry. The FAIS General Code addresses the concept of risk management in general terms, not prescribing specific requirements, but ensuring that the FSP takes notice and ensures that the general requirements are addressed in the business-specific risk management model, with specific reference to operational risk management. FSPs should ensure that they use resources, procedures, and appropriate technological systems that can be expected to reasonably eliminate the risk of clients, other providers, and representatives suffering financial loss through theft, fraud, other dishonest acts, poor administration, negligence, professional misconduct, or blameworthy oversight. The specific control objectives include that the internal control procedures of a business must be structured to provide assurance that the relevant business can be carried on in an orderly and efficient manner, that financial and other information used or provided by the provider will be reliable, and that all applicable laws are complied with. One of the questions in the compliance report relates specifically to the existence of business continuity planning in order to ensure that clients will be serviced if the business is terminated for any reason. The FSP requires that sole proprietors have contingency plans in place. One of the risks for consumers in the provision of financial services in relation to the phase-defined financial products is the recourse they have when the FSP fails in one way or another. The General Code states that the registrar may require providers to have suitable guarantees, professional indemnity or fidelity insurance cover in place. The General Code was amended in September 2009 to require specific cover for professional indemnity and fidelity insurance. New FSPs authorized after the 21st of September 2009 must comply with the insurance requirements within 6 weeks of authorization. The following is a summary of the insurance cover requirements effective from the 21st of September 2009. The General Code requires that FSPs or representatives must adhere to certain advertising principles. These principles are listed here. When a provider advertises a financial service by telephone, an electronic voice log record of all communications must be maintained. If no financial service is rendered as a result of the advertisement, the record need not be kept for longer than 45 days. A copy of all the electronic records must be provided on request by the client or the registrar within 7 days of the request. If the basic details of the product supplier provider are mentioned in the telephone conversation, then detailed disclosures of the name, physical location, postal and telephone details of product suppliers, conditions or restrictions, and full business details of providers, as well as information on providers' compliance departments, are not required. However, if the promotion results in the rendering of the financial service, full details required by the code are to be provided to the client in writing within 30 days of the relevant interaction with the client. Where a provider advertises a financial service by means of a public radio service, the advertisement must include the business name of the provider, as well as the fact that the provider is an authorized licensed FSP. The General Code requires that direct marketers adhere to certain advertising principles. When a direct marketer provides a financial service to or on behalf of the client, it must provide the client with the following information at the first reasonable opportunity. When a direct marketer provides advice to clients in respect of a product, it must at the first reasonable opportunity do the following. When providing advice, the following details of the product need to be provided. Before concluding the transaction, the following details need to be provided. A direct marketer must give the client a record of advice. A direct marketer must record all telephone conversations with clients in the course of direct marketing and must have appropriate procedures and systems in place to store and retrieve such recordings. Records of advice given telephonically need not be put in writing. but a copy of the voice logged records must be provided to the client or registrar within 30 days if they request it. A direct marketer must ensure that information regarding the product supplier, the FSP, and the record of advice, which had not yet been given to the client before the transaction was concluded, must be provided to the client in writing within 30 days after the transaction was concluded. The General Code addresses the requirements when clients want to terminate contractual agreements, as well as when the FSP or representative terminate their business operations or services. Subject to the record-keeping obligations of the General Code, and also mindful of any contractual obligations, the provider must, with immediate effect, allow a request from a client for voluntary termination of an agreement with the provider, or in relation to a financial service. The provider must take reasonable steps to ensure that the client understands the implications of the request for termination. Provider terminates business. A provider who stops operating as such must notify all affected clients immediately. The provider must also, if appropriate, take reasonable steps in consultation with clients and product suppliers to ensure that any outstanding business is completed promptly or transferred to another provider. When a representative stops acting as a representative for an FSP, the provider must take reasonable steps in consultation with clients and product suppliers to notify all affected clients and ensure that any outstanding business is completed promptly or transferred to another provider. A summary of the chapter. The General Code prescribes the manner in which clients' funds must be held in custody, which includes a separate bank account, written confirmation of money received and documents received, as well as adequate safeguarding of funds and documents. Adequate disclosures form the cornerstone of financial service. Disclosure of information relating to the product supplier, the FSP, commission, and product information must be done in the prescribed manner. Transparency is a direct result of adequate disclosure. Conflict of interest must be managed carefully, and there must be disclosure of any real or potential conflict of interest, which may influence the objective exercising of obligations to the client, or prevent the rendering of financial services in an unbiased and fair manner. Ethical conduct in the financial service industry begins with the individual taking responsibility for his actions and following the requirements for complying with the legislations. There are certain steps to be taken when giving advice to clients. These steps include establishing the suitability of products and services and recording the advice given. Although risk management is undefined in the General Code, it includes elimination of risk to clients through theft, fraud, other dishonest acts, poor administration, negligence, professional misconduct, or blameworthy oversights. Contingency planning is required to ensure that clients will be serviced if the business is terminated for any reason. FSPs must meet certain insurance requirements. The General Code prescribes the principles applicable to advertising, and this includes adequate warnings about products in certain circumstances. Direct marketing is prevalent in the SA financial services industry, and it is important that there are adequate measures to ensure that clients get all the information they need to make informed decisions. The General Code requires that direct marketers adhere to certain advertising principles. The principles are to ensure that there are adequate disclosures to clients and prospective clients. Disclosure includes the steps to be taken when a direct marketer provides advice for or on behalf of someone else, product information, and information about the product supplier. The manner in which complaints must be handled is prescribed in the General Code, and there is an onus on the FSP to ensure that the internal complaints resolution processes include a written complaints policy accessible to clients, acknowledgement of complaints, appropriate redress and investigation. Clients have certain rights to terminate agreements with FSPs. FSPs must ensure that there are adequate steps taken when representatives terminate the arrangements with FSPs in order to protect clients.